This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hello, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the Delphi trial because there were no cameras in there. So this is the trial of Richard Allen in the Delphi homicides of Abby Williams and Libby German. So we are on the defense's case. This is part 12. And on Tuesday, we went through the last witness on the stand was Dr. Eric Warren. He's a toolmarks expert, FBI trained, I believe. Didn't he say that? I can't remember now, but anyways, so Dr. Warren is still on the stand. We're going to continue his testimony with cross-examination. And then after that, Stacy Eldridge is a forensic data expert for the defense, and she's going to talk about Libby's phone. So that's where we are right about now. So let's get started, shall we? All right, so Mr. Luttrell is going to be doing the questioning for the state. Dr. Warren, you have used the term or phrase of mechanical fingerprint to describe a tool mark that a firearm can leave on a bullet, a cartridge, or a cartridge case. Is that correct? Yes, I have used that term previously. A mechanical fingerprint, so something that came off of the machinery when producing these things, when producing components of the firearms or ammunition. And that's what you learned that term. You applied it to your experience with the Tennessee Bureau of Investigation, correct? I was right. He was with the Bureau of Investigation. Yes, that is correct. So you have no written report in this case, is that correct? That is correct. I do not have a report. Why is that? It just was not something that came up in this particular case. You were just talking about the persistence of a firearms leaving individual characteristics, and that's been very well documented, as you indicated, absent some type of damage or gross misuse of a firearm in the intervening times. Is that correct? Yes, that's correct. In fact, those studies show that the first bullet fired from a gun can be compared with the 10,000th bullet fired satisfactorily. Is that correct? Yes, that there are tests that have shown it, up to probably 10,000 or even 20,000. So if there's going to be like a marking, a tool mark that is made, if a tool mark is going to be made on a casing in a particular gun or firearm, it's going to that tool mark that they leave, it's going to be for not just one bullet, it's going to be for every one up until 10,000 or even 20,000. So those markings can be repeatable. They have to be repeatable. And another point on that, they'll get into, I think, a little bit here on the machinery of it too, but the machines can make I guess ridges or whatever that might make it, make a tool mark, or where something might not be buffed out correctly, or there's like a little setting that's just slightly off, so there might be something that's rubbing against something, and then whatever. So that little error that the machine did, it's not just going to be for one gun, it's going to be for all of the firearms that run through there when this error is happening. So every time they are processing or making a new component for a firearm, it's going to have the same issue. It's going to, that tool mark can then be repeated from not just one firearm, but all of the firearms that were in that run, if that makes sense. And I think they'll explain it here a little bit better, but hope that made a little sense. So are you and you would absolutely expect a decently maintained semi-auto pistol, a SIG, for example, its individual tool marks to persist over a period of 5 years, even if it had been frequently used? Yes, I would. And that's actually a great distinction. These persistence studies are specifically for individual characteristics that we would be looking at. So it would continue to make that mark over time, even if you are using it frequently, because he says up to 20,000 times even. So let's look at subclass characteristics. Is that a new concern in the field of firearm examination? No, sir, it is not. It's been around for 90 years, correct? Maybe 90, yeah. So originally they were known as family characteristics, I'll say in the early days. I don't know that it's been 90, but it's probably been close to that. So the subclass or family characteristics is a way of breaking down or getting to the small part of the upside down triangle, correct? Yes, sir, that is correct. At the top of the triangle, we have all firearms, and then we have the class characteristics, which can eliminate a number of firearms, correct? Yes, that is correct. So, like a shotgun, a Sig Sauer, and a revolver are all firearms. But when you start breaking them down by, characteristics, they have many different characteristics. One has, the rolly thing. I have no idea what that's called, where you put the bullets in and the rolly thing in your revolver, like you see in all the westerns. Or you have the Sig Sauer, which you have a clip and you put it in there, or you have the shotguns where you have to load the pellets in um, up front. So many different distinctions between the three types of guns. So that's kind of what he's saying, is that you have like your characteristics that everything's gonna have. So that's number one. And then number two, you start to break it down by, well, this one has a longer barrel, this one has a shorter stock, this one I don't have no idea what words I'm saying. I'm just throwing out words that I've heard in reference to firearms. And mostly that's from A Christmas Story when Ralphie wants a BB gun. Anyways, so that's the extent of my knowledge of guns. But so at the top of the triangle, we have all firearms, and then we have class characteristics that we can eliminate in a number of firearms, correct? Yes, that is correct. So what would be a class characteristic in this case? So the a class characteristic in this case would actually, the main one will be the relationship of the extractor to the ejector. And so if you think about looking at a clock face, you would normally describe it. So you describe it from the position of the operator. So it's almost like an inverse clock face. But the extractor would be in roughly at 3 o'clock position, and the ejector is generally in the 7 to 8 o'clock position. So that relationship between the two and those orientations would be considered a class characteristic. Sir, when we talk about subclass characteristics, we're talking about the manufacturing process, the same tool, with approximately the same state of wear operating on the other tool, correct? Yes, that is correct. So subclass, as you stated, is due to that type of damage. So if the blade is a little off or whatever, is the easiest example to discuss, and it can persist for 10, 100, 1,000 different firearms that were made by that same tool. So like I said, it's not just going to be one, it's going to be multiple tools until that issue is fixed, until that machinery doesn't continue to do whatever it's doing that's making it a little bit off. But the point is, regarding firearms, is different tools manufacture different tools within the firearm, correct? It can. So with the advent of CNC machining that I mentioned earlier, A lot of times the same tools can work on multiple pieces of the firearm. So for instance, that SIG video that we watched described the different CNC machines that have multiple axes, and all the operations can be performed on those two major components using the exact same tools. But we were talking about an extractor. I'm sorry, an ejector. Um, a different machine makes the ejector from the extractor, correct? I don't know if that's correct for the SIG. I would guess that yes, that is correct. So sometimes these parts are stamped, so it'd potentially be the same machine, just a different die. But yes, my expectation would be that in this case, the extractor and the ejector were made by two different tool mechanisms. And the chamber face, or you call it the barrel hood, that's made by a different machine as well, is it not? Again, so different from the extractor and the ejector, yes, but potentially the exact same as the slide and the frame. And this firearm is assembled, generally speaking, these firearms are assembled by an individual reaching into a bucket and pulling out an ejector or extractor and assembling it on the firearm, correct? Yes, that is correct. So not only are these weapons being, moved around through a manufacturing process where there's machinery, there's things making stamps, or something might be off and you could be making pieces a little bit off. So meaning that they would like leave a mark when you fire a bullet out of them. So that's what we're looking at. During the manufacturing process, all of the machinery and everything it's touching, and there's chances that it could get a flaw that might make a tool mark, right? So, and it's not just one, usually we know now. And in this case, the firearms are being hand assembled by individuals now. So he says, or the question was, the extractor and the ejector are different, but potentially. Oh, wait, I'm sorry. The question was firearm is assembled, generally speaking. These firearms are assembled by an individual reaching into a bucket and pulling out an ejector or an extractor and assembling it on the firearm. So think about that. Now you got all these printed pieces of metal that you need to, assemble into some other pieces. And um totally lost my train of thought right there. Wow. I'm sorry, guys. That was weird. Um, maybe it'll come to me. But imagine being on that assembly. I don't know. Oh, and then having to put it back together by hand, or putting things together by hand, but your things in the bucket. So all the little pieces of metal, all the little components and the parts for this firearm that you have to put together. So you're a human, and I'm sorry, but you're just flawed because you're human. We all make mistakes. You could have a bad day that day. You could be fighting with your loved one. You could be, grieving a loved one. You could be just, you didn't get enough sleep that night and you're like, I don't want to be here. So during that time, you could be, moving and shifting things around, and things could get scratched up in certain ways there if all these pieces and components are just in a bucket and they're just fishing around trying to grab a piece so that they can put it on and assemble. The answer is yes, that is correct. They are hand assembled with an individual pulling items out of a bucket to put on the firearms. Yes, that is correct. So as the parts come off the line, the assembly or the manufacturing line, they are typically stored in some type of bin in the assembly station, and the individual that is doing the assembling is just reaching into a bin of that particular lot of tools that are made at that time to assemble the firearm. So it's just reaching into a bin and picking out your tools. Don't you think pieces are going to rub together and maybe get scratches and you could originate if the cops wanted to do a thorough job, they could have investigated the manufacturing process of the firearms, especially the one that Richard Allen had, and to see if there were other flaws, other makes, other models, what the things that were going on with his firearm that, they say is going on, even though it doesn't match an unspent bullet. But they could have easily gone and done a little more investigating, gone to get these get this data in their investigation so they could decide if there was a manufacturing issue, things along that nature. Okay. Throat is dry. All right. So he says yes, they just reached into a bin and moved all that stuff around, getting it all scratched up and making possibility for tool marks. But that lot may come from a whole different company, but the company has contracted with to make an ejector or make an extractor, correct? Yes, that is correct. Thank you, sir. I appreciate that. Once you are talking subclass, if we think of, I'll use the word funnel instead of triangle. Once we're down to a funnel, we're way down towards the bottom of that funnel by the time we're distinguishing between subclass and individual characteristics. Isn't that correct? No. I love when experts like, no, that's not right. To an attorney. I would not say that is correct in every case. It will depend on the manufacturing technique potentially. It could be anywhere. It's not a linear continuum, we'll say. So it could fall anywhere between the top of the pyramid and the very bottom of the pyramid or funnel. Well, in fact, even sequential serial numbers on a firearm may vary in terms of their subclass characteristics and may not share subclass characteristics. Isn't that correct? Yes, that could be correct. Again, that's why the documentation of the evaluation of that subclass potential is so important. You were a firearms examiner for TBI for once you finished your training for 6 years, correct? 6, going on 7. Yeah, somewhere in there. You were 1 month beyond 6 years. Isn't that correct? No, I believe it's more than that. Maybe it was close, maybe 2 or 3 months over. You said you started you started in August of 2019 with your training video or program. Why am I throwing words in there that don't belong? Stop it, brain. I'm sorry. Get it together, Heather. Okay, so you said you started in August of 2009 with your training program. Is that what your CV says? Yes, that's what my CV says, and that is correct. And you left TBI in October of 2017, correct? Yes, that's also correct. A trained, experienced firearm and tool mark examiner would always consider the potential for subclass, correct? Yes, that is also correct. And in the report that Ms. Oberg documents, she indicated she had concerns about subclass on the ejector and pursued that further, correct? Yes, after she documented that her concern was present, she did do additional investigation into the ejector specifically. And she did not articulate in her report any concern about the extractor or the chamber face for subclass characteristics. Is that correct? Not entirely. So there's no documentation that it was even considered at all. So we don't know if she. You didn't answer my question, Dr. Warren. I apologize for interrupting you, but you have. Would you answer the question? Did she? Judge, can we please, says Mr. Rosie. Did she articulate, Mr. Rosie? That was Mr. Luttrell. Mr. Rosie says, allow Mr. Warren to answer the question. Court says, well, let him ask the question that he wants to, and him answer. So, did she articulate any concern, Dr. Warren, about subclass characteristics on the extractor and the chamber face? There were there was zero documentation of any evaluation, so there is no way to know if there was a concern regarding the presence of subclass on these other tool faces. I'm going to ask that question again, Dr. Warren. I would ask you answer my question. Did she document any concern for that she had for subclass markings on the extractor for the chamber face? Objection. Asked yes or no. Asked and answered, says Mr. Rosie. Mr. Luttrell says it has not been asked or answered. Mr. Rosie says he said he's going to ask it again. The court says not this one. Overruled. Did she document any concern, sir? There was no documentation or any evaluation or any resulting concern. Mr. Luttrell says, Your Honor, he's not answering my question. He's giving a speech to the jury that he wants to give. I'm asking the question. I would like him to answer my question. It's a yes or no question, sir. Did she document any concerns that she had for subclass characteristics on the extractor or the chamber face? As I've studied, there was no documentation of any concern or any evaluation. Mr. Luttrell says, Your Honor, I would ask him to directly answer my question. The court says, Sir, it's a yes or no question. Yes or no? And the answer is no. Well, do you know how many years Ms. Oberg had a gun and a tool mark examiner at the time that do you know how many years she had as an examiner? I don't know why I read that completely weird. Sorry. Do you know how many years Ms. Oberg had a firearm and tool mark examiner as a tool? I did it again. My eyes are tired. I'm really sleepy. Do you know how many years Ms. Oberg had as a firearm and tool mark examiner at the time she did this examination in October of 2022? I do not know how much time she has. Well, she had. Would you be surprised to know that she had well over the amount of time you'd have that you've had to be a firearm and tool mark expert? No, that would not surprise me. Time does not factor into my mind. A good firearm and tool mark examiner, would conduct research all the time while they're doing their craft, their discipline. Is that correct? No. It would depend on what was in front of them. So if it was something that was routine, I would not expect there to be additional research that was performed. But they're always doing research as they're being tool mark examiner. As they're being tool mark examiner, correct? I'm gonna objection to speculation on what a good firearm examiner should do. Yeah, I don't know what he's basing that on, but sustained. Mr. Luttrell says, We have the board of AFTA here, Your Honor. A board member of AFTA, I think he can answer. Well, let me rephrase it, and he can answer it. Rephrase it then, says the court. Sir, does AFTA encourage its members to continue to do research as they're maturing and gathering knowledge on firearm and tool mark examinations? No. So AFTA does encourage research by its sorry. So AFTA does encourage research by its practitioners. It does not qualify that the research should occur by one case to the next, and in fact, I would disagree that that even happens. Well, they encourage them to do a research and gather knowledge, correct? Yes, that's correct. Are you suggesting to the jury that Ms. Oberg, after examining the ejector and noting potentials for subclass characteristics, forgot about subclass characteristics when she examined the extractor for the chamber face? I'm saying that it's possible because nothing was documented regarding that process. And do you know, or do you always pull all of your research and your knowledge that you'd gained in your 6 years at TBI into a report and document everything about your experience and training that's led you to your opinion? Yes. So, in my 6 years with the TBI and in my 14 years with doing this, if I do research that is specific to my conclusions for a particular case, I make every effort to document all of that to the best of my ability. So, everything you rely upon in your examination, everything that you've learned over time, everything you've learned to distinguish subclass from individual characteristics, you actually attach that to your report? No. As I stated just a second ago, anytime I have to do research for a specific case, something that directly relates to my opinion in that case, I do note it. Ms. Oberg identified three different tools uh, oh my God. Let me take a break and then I'll come back, hopefully a little bit more refreshed. All right, I am back with coffee. Hopefully that helps me a little bit. It's helping my brain a little bit. All right, so Ms. Oberg identified three different tools having made, whoops, I guess I probably should move the mic closer to my mouth. Ms. Oberg identified three different tools having made tool marks on this particular cartridge, item 016. Is that correct? Yes, she did determine actually the three tool marks were what she based her opinion on. And that basing her opinion on three separate tool marks, that strengthened her opinion that she ultimately came to identifying the defendant, Sig Sauer, as having cycled from the item 016. Is that correct? Item 016 must be the cycled bullet. His answer is, I don't believe that. Mr. Rosie says, I object to speculation about what was going on in her mind at the time when she made these conclusions. I don't think he's in a position to testify about that. Mr. Luttrell says, I'll rephrase the question. The court says, okay. This shit's crazy, man. This whole trial is crazy. And knowing what we know with the brief and the appellate, uh, his original appellate brief and then the reply brief that they just had just solidifies how badly Richard Allen was railroaded by the state. And you can see how they just won't let him get into anything. Like we've been seeing how there's so many objections. Like the one guy couldn't even talk about Allen, even though he was there to talk about the psychological effects of of isolation for so long and or solitary confinement and him being in it for 13 months. He couldn't even apply his knowledge of solitary confinement to what he saw and observed of all of the evidence of Richard Allen. Like he couldn't even say the defendant's name. Objection. Anytime he said his name. So it's just crazy shit that the state is trying to pull. If you're paying attention and looking at it, looking for it, you can see it. If you're just a juror going da 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 da, you don't notice it. You don't notice it. All right. So the court says, okay, the fact that she notes three different tools that she identified as marking, making specific distinct tool marks on the cycled cartridge, strengthened the result that she obtained. Isn't that correct? I don't believe that it strengthens the results. There was subclass agreement noted on the ejector. There was some agreement which does not meet the AFTE or the AFTA sufficient agreement stated by her and her report on the extractor, and I didn't see any agreement on the barrel face. So to me, no, they do not strengthen the final conclusion. Bam! He just said, nope, Ms. Oberg's opinions are hogwash. She didn't have enough sufficient agreement to meet the AFTE or the AFTE standards. I'm just saying AFTE. I have no idea what they call themselves, but that's what I'm saying. I just make up my own pronunciations if I don't know. Mm. So the next question, Ms. Oberg found agreement on the chamber face markings and of the defendant's SIG, an item 016 though, didn't she? She does state that she found some agreement. She found some sufficient agreement, didn't she? No. So her case file says some agreement. The report does indicate at the bottom there's a stipulation that when she reaches an identification, that is sufficient agreement, but it's not reflected in the notes portion where she was showing her work and illustrating that basis. So in her own notes, she didn't even say that it was sufficient agreement, sufficient enough to be a match. The bottom line on the question, the bottom line is a tool mark is a tool mark when you're talking about cycled only versus fired cartridges. Isn't that correct? No, that's not correct. So the task of the examiner is to look at the fired test casing and see if it actually creates the similar markings that are on the question item 016. Isn't that correct? Yes, as I testified earlier, it's the reproducibility and the repeatability of a particular tool mark, that of a particular tool, that needs to be evaluated. So it's the thing that needs to be reproduced. And it would be reproduced over and over and over again. It's not going to stop. So if Alan's gun is going to make a particular mark when he cycles it, then when she goes to cycle a casing, it should make the same marks, and it's not. So it's not apples to oranges. She's actually confirming, an examiner can confirm that the test fires are appropriate and adequate to compare to the cycled cartridge, correct? So it's not apples to oranges. She's confirming that the test fires are appropriate and adequate to compare to a cycled cartridge. I don't know why you would find that appropriate. And what, like, he's testifying here almost, but in a way making it like her opinion. Well, that is something that can be determined, but specifically in this case, she actually determined that it was not sufficient, that she could not find the agreement from the fired cartridge cases to the cycled cartridges. What? So she actually determined that it is not sufficient. The fired cartridge versus the cycled cartridge. She even says that it's not sufficient markings in her notes. In fact, she found that she could find the test fired cartridge was suitable for comparison to 016, correct? So that was her conclusion, yes. That's the witness. That's what she decided. That's not necessarily what any other examiner would say or do, but that's what this one did. In fact, you just did that in front of the jury with Defense Exhibit 00, isn't that right? You'll have to clarify what that is. You documented for the jury that you could use that the ejector mark from the test fire was suitable for comparison to 016, the cartridge. No, sir, I did not testify to suitability of anything. I simply looked at the photograph itself and pointed out what was visible on that photograph. So he did not testify to suitability of using a fired versus a cycled or whatever, a fired round versus a cycled round in this. I asked you earlier if you actively used CMS, and you said you do actively use it. Yes, sir, I do. And in 2021, you testified in the 2 years ago, October of 2021, that you did not use CMS, correct? So I'm not sure which case you're referring to, but if that was my testimony, it was probably that I didn't use it in that particular case. So with CMS, it is mostly, well, only applicable to striated marks, not impressed marks. So if there's, let's say, a firing pin impression, that would not be something that would be amenable to CMS. The way I teach it to police departments, crime laboratories in the country, and in Morocco, Mr. Luttrell says, Your Honor, I think he's answered the question, so I appreciate his answer, but he's continuing to answer after he's answered my question. So I would object just one moment, Your Honor. Where's Rosie saying, excuse me, let him finish his answer. Mm, I don't know. I don't like it. I don't like they're always cutting off the experts, the defense experts. Sorry, I'm trying to adjust here. Got the puppy on my lap and the mic's not quite lined up right, so I gotta adjust my seat. All right, so he objected right through that, and he goes right to the next question. He doesn't even he just says just one moment, Your Honor. Like he doesn't even ask for her to rule because you know she's going to rule in your favor. Would you, and you received training, you indicated in 2022 or 2023 on that use of CMS? Yes, sir. That's some of the most recent trainings where Mr. Murdoch invited me out. Yes, sir. And you were trained to use another examiner's photographs that were created to show one aspect of the firearm in your evaluation of CMS. Yes, sir. During the training course itself, that's exactly what it was used. What is used is the photographs that another examiner had taken. And when you were you trained that you could go into court and testify on CMS based upon your examination of another's examiner's photograph? Yes, and in fact, that regularly occurs. You can base your testimony on viewing photographs of the evidence, not just having it in your hands. Are you the Dr. Warren who testified in the case in Flagstaff, Arizona in 2021, October of 2021? I have testified in Flagstaff, Arizona. I will have to take your word if you say it was 2021. I don't recall. And did you indicate in your interview in that case that you do not use CMS methodology? I don't recall an interview associated with that case, but again, it might have been a situation where it wasn't applicable, or yeah, I didn't use it in that case if it specifically was asked whether I used it in that specific case, but I don't recall. Do you recall telling them that it's a West Coast thing? It's not something that you do or that's done in the Midwest or the East Coast? Yes, that's certainly true. So, CMS was started in 1959 at UC Berkeley, and so that is generally where you find the majority of practitioners. It has migrated, across the US, but as I stated earlier, there are some laboratories that do not use it. Have you testified in the past that you cannot come into court and offer a conclusion based upon photographs alone? Mr. Rosie says, I'm going to object to that. That's asked and answered. Overruled. Mr. Rosie says, thank you. Have you said that? Says Mr. Luttrell to the witness. Can you repeat the phrase that you used? Have you testified in court that you cannot render a conclusion on a result by looking at another examiner's photographs alone? Yes, I can imagine there are situations where the photographs are such that I could not testify to any specific conclusions. Maybe you need good notes from your examiner who originally looked at the evidence. Did you say because you need to look at the exhibits yourself on the microscope and look at it all different phases and possibilities, you would not make a conclusion of a handful of photographs? Were those your words? Again, I don't recall the specifics of that. I could certainly imagine that I think in the Flagstaff case, Those bullets were very soft lead bullets fired through a micro grooved barrel, which means they're teeny tiny marks. So it is possible, and that I would say along those lines that yes, in that particular case, there'd be so many different phases and possible combinations, and things would be so microscopic that I would need to physically examine the evidence in order to render a conclusion on the source opinion. You did not say that, quote, in this particular case, I could not. You just said, as a general rule, you could not render an opinion based upon a handful of photographs. Aren't those your words under oath? Like you're trying to maybe take something he said out of context just to make him look bad. And at this point in time, does it even effing matter? Like this is all you've got to impeach him with? That he said he uses a program in some cases and maybe not others? Like, really? This is what you've got. This is all the state has. They've got nothing. So they have to tear apart the poor witnesses that are here. He says again, that may be my exact wording. I'm not sure. I can only say that my recollection right now is with that case in those specific situations. Yes, that would be a correct statement, is that I would not or would not even look at the photographs and make a source conclusion determination from the photographs. What's the most important? Well, we'll withdraw that and ask you, what's the most, you have your own laboratory, correct? Yes, I do. And it's not an accredited laboratory. No, we are not accredited. But you have testified that you have tried to make it up to the standards that would be required by accreditation. Yes, I would say that we meet the standards of accreditation. Of course, the whole concept of accreditation is you not making that decision, an outside party affirming that. Isn't that the whole point of accreditation? No, the way I understand accreditation, essentially, you are paying a body, a peer of yours, to come into your laboratory and look at your procedures and then look at let's say, 5 cherry-picked cases and make sure that those specific cases that were presented to your peer accurately reflect that you are doing what your policies say. So it sounds like you don't have a lot of confidence in accreditation. I do not have a lot of confidence in accreditation that in certain circumstances would be fair. And as an example, the Rhode Island and the Wyoming crime labs are both accredited. Well, what's the most important tool in your laboratory, sir? You'll have to be more specific. I have many tools that are very important for specific tasks. Well, what's the most important everyday tool you use in firearm toolmark examination? In firearm and toolmark examination, the most important tool would be myself. He called himself a tool. That's not what I was laughing at. Like, I'm laughing at you're trying to get him to say, like, oh, it's my microscope or whatever. It's like, no, it's me, my knowledge. The stuff that's in here is more powerful and more important than any old tool in my laboratory. So that's what I was laughing at, but also the fact that he called himself a tool. How valuable to you is your comparison microscope when you do examinations? So, if you're conducting microscopic examinations, then you would need to have a comparison microscope in order to accomplish that. How crucial and essential is that if you're going to make an examination, to use your comparison microscope? If you're going to do a comparison of the physical items of evidence, then you would need to use the comparison microscope to do that. And why is the comparison microscope so central to firearm toolmark examination? Mr. Rosie says, Judge, I'm going to object at this point to relevance. He's just asking broad based questions that have nothing to do with this case. Mr. Luttrell says, oh, it has everything to do with this case, Your Honor. I disagree. The court says, overruled. Why are your comparison microscope Why is your comparison microscope so critical to your examination of the evidence? Again, my comparison microscope is one tool that I have. It is one that is necessary according to our accepted policies or practices in order to do a comparison. And because that's an accepted tool, that's something that is necessary to do the job. I don't know what else I can say about that. So you could either use it or not use it when you do an examination comparing testifiers to an unknown piece of evidence. Yes, sir. You can use that tool or you can use another tool like a 3D microscope. There are multiple different tools that could be used. You were trained on the AFD standards manual. So I was trained using the TBI training manual, but it was based on the AFD training manual. And despite the questions Mr. Rosie asked you about critics of firearms and tool marks, you strongly endorse the AFD manual and its methodology, correct? So, for firearms examiners, I strongly recommend AFD membership and participation. I don't have a specific strong recommendation or whatever your term was for how an agency uses that particular training notebook. They are provided to AFD members as guidelines and as some type of starting point for the agency to take it and make it their own. So it sounds like the comparison microscope, you can take it or leave it, is what you're telling us today. If you want to look at it that way, sure. Like, who gives a? Why are you going back to that? Like, what do you care? He's the sharpest tool in his toolbox. The role of a forensic scientist is to let the evidence speak for itself. Is that correct? Yes, there. Mr. Rosie says, Judge, I'll object again to relevance. We're talking very broadly here. The court says, sustained. You have used the term yourself in talking about your role in firearm toolmark examination that you let the evidence speak for itself. Isn't that correct? Same objection, says Rosie. Overruled. Is that correct, sir? Yes. So those are statements that sound familiar, like something that I would make. And is that something you would take it or leave it, or is that something you firmly believe in? No, would firmly believe that a forensic scientist, or even outside of forensics as a scientist, I'd document the evidence to the best of my ability and then demonstrate that evidence and let it speak. You offer services to individuals or institutions that wish to hire you that you can do consulting, like you've done in this case, correct? Yes, sir. So I have a website and an email address and a phone number published. I'm equally available to whoever needs those consulting services. And you part of that consulting is in reviewing documents and giving your opinion about those documents, that documentation. Isn't that correct? Yes, that is correct. And thank you, sir. Routinely review. You've answered the question. I appreciate that. And you also do your own examination on evidence in cases. Isn't that correct? If that is something that, yes or no, sir, is requested, then yes, that is something that I'm capable of doing. So when you were asked by Mr. Rosie if you had received everything you needed in this matter, that did not include item 016 or the various firearms in this matter, including the defendant's firearm. You didn't ask for those, did you? I don't remember what the discussion with the attorney was regarding that. Again, to dealing with the request to review the documentation, I did receive all the documentation and would not need the bullet or the cartridge case or guns in order to review that documentation. Well, not only your website, sir, but you yourself expressed to the defense that you could actually test these specific items, correct? Again, I do believe that was a discussion that occurred. Thank you, Mr. Warren, in this particular case, but I couldn't say for certain. You believe that you did? Yes, sir, I do believe it. I did. And you know that whole process, how an order is how an order is sent to the court to obtain the evidence from the Indiana State Police, and it's appropriately shipped to you in your laboratory where you can examine under your comparison microscope, should you choose to do so. this evidence and test fires that you yourself would take, correct? I'm not familiar specifically with the process in this state, but generally what we just described is the most common occurrence whenever I do physically examine evidence. Did you ask the attorneys for that opportunity? Again, I don't remember. This was over a year ago where these discussions probably would have occurred. I do make it a routine to explain all the services that I can offer. Physical examination of the evidence using a comparison microscope is one of those options. Regarding that, if you have received these items to compare the defendant's firearm with 016, create your own test fires and test cycle and compare them to 016, would you have decided to use your comparison microscope to do that? Mr. Rosa says, I'm going to object at this point. This calls for speculation and overruled. Hmm. Would you use your comparison microscope if you had been asked to do that and actually had the items? If I was asked to perform a physical comparison of items, then yes, that would entail a comparison microscope. You wouldn't have a take it or leave it approach to the comparison microscope in that situation, would you? Again, it would depend on what the request was. If it was to examine physical items of evidence together, then I would expect to utilize the comparison microscope. This is the defendant's exhibit 0, or I think it's O. That's a static photograph. I thought that said satanic for a second. The coffee woke me up, but I'm still seeing words that aren't there. All right. So this is the defendant's exhibit 00. That's a static photograph, correct? Yes, that is. That photographs are static. I like his answer. Yes, photographs are static. And if you are looking at this image on a comparison microscope, any slight adjustment or move would change all of this lighting, all of the lighting that you testified to the jury about, correct? No, sir. So the surface does not change just because you move something back and forth. So you might illuminate things slightly differently, but things that are there are not just going to not become there anymore. So something that's there isn't going to just disappear. But the photograph could look different, could look entirely differently if you adjust the image or the lighting, correct? It is possible that the photograph could look different if you adjust the lighting or the position. That is correct. I have no further questions. Thank you. Like he really made a point there. Mr. Rosie, says the court, and he says, yeah, thank you, Judge. All right, so Mr. Rosie says, Dr. Warren, how long ago would you estimate it was that we first started working together? It was over a year ago, I would say. So based on my case number, in this case, it would have been before September of last year, so more than a year ago. This trial took place in, I want to say, October, November of 2024. Okay, and did I ask you to generate any reports? I do not recall that request. No. Okay. Did you make yourself available to the state of Indiana when they wanted to depose you? Yes, I did. And approximately when was that? It would have been, so I was in Morocco at the time, so maybe 3 or 4 weeks ago. Nothing further. Mr. Luttrell says, I have no questions, so that's it for his testimony. The court says, does anybody on the jury have any questions for Dr. Warren? All right, would counsel approach? So we have a few questions. And now we're at a sidebar with the judge and the attorneys. The court says, okay, tons of notes. You stated the change of position and a slight turn of the tools in a handgun can change the marks on a cartridge. How would CMS or objective testing be usable? Mr. Rosie says, I don't care. Luttrell says, sure. The court says, would removing, disassembling, cleaning, etc., change the position of individual striations? And if so, would you have to test a cartridge in all iterations to consider it objective and or relevant? Would you have to test a cartridge in all iterations? Sure. says Mr. Luttrell. Mr. Rosie says, I don't know the answer to that. Court says, are you okay with the question? I'm okay with it. I don't even know what the question is. If you have to test a cartridge in all iterations, would you consider objective and or relevant? I don't know. Okay. Mr. Rosie says I'm okay with it. The court says, do you know if the manufacturer keeps track of subclass characteristics? Mr. Rosie says that's fine. Mr. Luttrell says if he knows. This is something that would be, if you could go back to the production lines and find out why are guns making this particular run, making this particular fire mark or tool mark. Mr. Rosie says that's fair. Luttrell says if he knows. The court says, would the presence of subclass characteristics only be something to acknowledge in pursuit of individual characteristics? Mr. Rosie says, I think the answer is clearly yes, but I think it's confusing. The court says, I have no idea half the time what I'm reading. Is there a reason you didn't verify? Well, like she wasn't reading any of the defense's pretrial motions, like the Frank's motions. She wasn't reading those. Is there a reason you didn't verify the results in the report by conducting your own analysis rather than reviewing the pictures and findings of Ms. Oberg? No objection. Mr. Rosie says, I think that's fine. The court says, would doing your own analysis have been more conclusive? Fair. The court says, do you believe that using 2 runs of 3 or 1 run of 6 would be the gold standard to observe sufficient analysis, and would you have done this to come to any conclusions about the items? Mr. Rosie says, kind of loaded. The trial says, yeah, I get what he's asking, though. Kind of. The court says, is that okay? Mr. Rosie says, it's somewhat consistent with the testimony, I guess. Mr. Luttrell says something inaudible, but we don't know. But he also says it's fine. The court says, okay, would individual marks be lighter or darker depending who is manually cycling the cartridge due to the force? They tried to get into it a little. Mr. Rosie says, yeah, I'm not going to object. The court says, do you look at the subclassification marks on the cartridge? Mr. Luttrell and Rosie say yes. The court says, what is the relevance of the cartridges having similar subclass characteristics? Mr. Rosie says, oh, geez, they must not have been here for the last. The court says something, Mr. Rosie says something, then the court says okay, then Mr. Luttrell says something about Ms. Oberg, but that's also inaudible. So there's a whole bunch of conversation that we're not privy to. So even though this is supposed to be the record, I don't think this is the record. There's so many inaudibles in here. I think it's the court covering its butt. This is their way to redact something. Oh, I just didn't hear it. Okay. Yeah, maybe you need a hearing aid, lady, because you missed a lot of sidebar conversations. The court says, are sequential serial numbers to guns made within the same lot, assuming that there isn't a change in the lot numbers? Wow, we're in the weeds, says the judge. Mr. Rosie says, I don't think he really talked about. The court says, you didn't. Mr. Rosie says, serial numbers, though, did we? The court says, he didn't. You didn't really. Mr. Luttrell says, I asked him a question about the machines. Mr. Rosie says, yeah, the tooling. The court says, okay, so no? Mr. Rosie says, that just goes to the something inaudible and the frame. Court says, yeah. Mr. Luttrell says, the video talked about that. Court says, so yes. Mr. Rosie says, sure, ask it. I don't care. The court says, this one's real weedy. Can you speak to the 1.5% false positive and 2.8 false negative percentages in consecutively made tools? Where'd they get that stat from? Do they get the evidence like handed to them the next day, maybe? Or at the end of the day, and they can look through it, and so maybe they got that from a report or something. I'm not sure. Mr. Rosie says, sure. The court says something inaudible. Mr. Rosie says, it's not. That's not really. Actually, that question is just entirely wrong. It's conflating two totally separate issues. The court says, I thought we were into separate. He talked about error rates, says Mr. Rosie, but not in. The court says, not in this. Mr. Rosie says, in the course of making tools. The court says, okay, so no on this one. Okay, thank you. That was my memory as well. Ms. Oberg cycled numerous dummy cartridges through Mr. Allen's gun with the same characteristics and markings. Are you saying these are false findings? Mr. Luttrell says, she didn't do any dummy. The court says, Negative response. What does that mean? Oh, like, like, no, I don't know. Mr. Rosie says, plus, it's not a true statement. So the court says, okay, so no on that. Mr. Rosie says, so that tells us she doesn't know what's going on. The juror doesn't know. She wasn't paying attention. Are you certified? Are you a certified firearm and toolmark examiner? Mr. Luttrell says, yeah. The court says, have you completed proficiency testing and black box studies? Oh, nice. Somebody was paying attention. Paying attention, yeah, says Luttrell. The court says, so okay on that one. Mr. Rosie says, I'm okay with that one. I don't know that those things are really mutually exclusive. Proficiency testing and black box studies are not. So no, they're not related. He could answer it, says Mr. Luttrell. Mr. Rosie says, I don't think it's. Mr. Luttrell says, it's kind of mixing the two things. The court says, okay, so no on that. Something inaudible. And then, are you aware that the ejector from Mr. Allen's firearm had a recessed portion which caused individual characteristics on the cartridges and dummy cartridges similar to the cartridge found on February 13th, 2017? Mr. Rosie says that's pretty intuitive. Mr. Luttrell says, I'm sorry. The court says, are you aware that the ejector from Mr. Allen's firearm had a recessed portion which caused individual characteristics on the cartridges similar to the cartridge found? I'll strike the dummy cartridges. Okay, is it normal? Oh my God, they won't stop. Are you aware that Ms. Oberg's findings were verified by a separate party and this party or identifier agreed? That's fine, says Mr. Rosie. She testified about that, says Luttrell. The court says she did. Mr. Rosie says, about going through the verification. The court says, verified by a second party, it's a normal practice for you to not issue a report when conducting examinations or consultations. Mr. Rosie says, well, he didn't do an examination. Court says, well, it said when conducting examinations or consultations as you did for this case. If not, please elaborate why a report was not included in this case. Why not, says Mr. Luttrell. The court says why a report was not. So both of those are okay? Mr. Rose says, yeah, I think they're fine. The court says, and what are the chances that the cartridge found at the scene would have the same subclass markings as the Indiana State Crime Lab test round? Ooh. Somebody thinks that the markings on the crime scene casing have similar subclass markings as the Indiana State Crime test round. Their own test round that they fired. Miss Rosie says that's very intuitive. The court says, wow, okay. And then we break for lunch. She didn't like that. Miss Rosie says, okay, sidebar over. Now this is in front of the jurors. And the court says, okay, lots of questions. Yes, says the witness. Okay, you stated that the change of position and slight turn of the tools in a handgun can change the marks on a cartridge. How would CMS or objective testing be usable? So the CMS or the standard pattern matching would still apply the same way. The question would just become, does it meet the examiner's sufficient threshold or does it meet the CMS threshold? And what the study showed is, like I said, with just a minimum of 15 degrees, the surface contour would change enough that it no longer met that threshold. Okay, Mr. Rosie, no questions. Mr. Luttrell, no questions. Okay, would removing, disassembling, cleaning, etc. change the position of individual striations? And if so, would you have to test a cartridge in all iterations to be considered objective? No. Just cleaning or disassembling and reassembling the firearm would not change the individual characteristics unless some damage had occurred. So if you take the gun apart and say dropped a piece on to the asphalt and something rough, there's the potential that you could change. If that occurs, you would have to do testing. Hopefully, you'd have the testing from before the disassembly occurred, and then you'd also have to test after the reassembly occurred to determine if the damage actually did affect the individual characteristics or not. Court says, Mr. Rosie, no questions. Mr. Luttrell, briefly, Your Honor. As it relates to the extractor in this case, there was no photograph of the extractor, correct? That is correct. There was no direct photograph of the extractor. I mean, the extractor is visible in some of the macroscopic photographs of the whole firearm, but to actually see the whole working surface, there was not a photograph. So you'd have to disassemble the firearm, correct? Yes, you would. And that could lead to problems if there ever was another examiner deciding to test that firearm after you disassembled it, correct? No, sir. So again, as only if it had been dropped and damaged, but prior to that, you would have tests made before it was then disassembled and reevaluated. I have no further questions, says Mr. Luttrell. Back to jury questions, the court asks, do you know if the manufacturer keeps track of subclass characteristics? No, manufacturers don't keep track of that kind of thing. It's all macroscopic that pertains to what we do, not so much to what they do. So that's why they can't just go to the manufacturers and be like, so tell me the runs that you had and which ones might have this defect in it or whatever. Mr. Luttrell, Mr. Rosie, no questions. Is there a reason you didn't testify the results in the report by conducting your own analysis um, rather than reviewing the pictures and findings of Ms. Oberg? He says, so in that particular case, that's what I was testifying to earlier. That was a discussion that for whatever reason, we decided or it was requested of me to evaluate the documentation to see if there was even sufficient documentation to support a particular conclusion that was reached. So my role, as I saw it and was discussed, is to both educate the attorney on what the conclusion was and then to explain if the documentation supported that conclusion or not. Mr. Rosie, he has a follow up and says, I mean, is that something you do on a pretty routine basis in your line of work? Yes, this is pretty common practice. Okay, nothing further. Mr. Luttrell. So it wasn't a big deal that he didn't make a report. Who cares? But they wanted to make it look like a big deal, and it worked on some of the jurors, or at least one of them, because they asked the question about why you didn't make a report. You made it clear you could do an examination, and the defense did not ask you to do so, correct? You made it clear you could do an examination. Yes, I would say that that was not a request that was made that I recall. That is something that I could do if it were requested, I guess. Anything else, Mr. Luttrell? No, I'm sorry, Your Honor. The court says thank you. Luttrell says no. Okay, back to jury questions. Would doing your own analysis have been more conclusive? So it's hard to say without actually doing analysis. It could have. There's the potential that it could have said, hey, I agree with her. There's also the potential that I could have gone the exact opposite way and say, there's absolutely no way this could have happened. So my opinion as it stands is that the documentation does not support a conclusion of same source, but for me to actually give that opinion of same source or a different source, that could be changed by the examination of the physical evidence. Mr. Rosie? No questions. Mr. Luttrell? No questions. No, I have questions. What the hell is he talking about? want to know more about that. Okay. So do you believe that using 2 runs of 3 or 1 run of 6 would be the gold standard to observe sufficient analysis? And would you have done this to come to any conclusions about the items? So yeah, CMS that you have the option of either or. So as in terms of which one's the gold standard, they are both. They're equal, on equal footing, either at least 2 runs of 3 or 1 run of 6. And I'm sorry, I don't know if that answered the question. Uh, I like, I feel like there was more, but the court says, go ahead, Mr. Rosie. No questions. Mr. Luttrell? No, Your Honor. Are you a certified firearm and toolmark examiner? Yes, I am. Mr. Rosie? No questions. Mr. Luttrell? Certified by whom, sir? Certified by the Association of Firearm and Tool Mark Examiners, or AFD. The people who do this all day, every day, 24/7. The people who know what they're talking about. They're the only ones in the world that offer that certification. Mr. Luttrell says, thank you, no further questions. So you just solidified his credibility, but it doesn't matter because the jury didn't see through the state's BS. Next question. Would individual marks be lighter or darker depending who is manually cycling a cartridge due to the force? So manual cycling can change both the force and the angle because of the force that is involved in the marking. That's why I mentioned the apples to oranges comparison earlier. Okay, Mr. Rosie. No questions. Mr. Luttrell. I feel like he wanted to say something more about this, but I guess not. Mr. Luttrell says, the greater the force used in the whoa, my dog is seriously shaking. He's shaking the whole computer. Sorry about that. The greater the force used in the manipulating the slide can make more pronounced, prominent, I should say, marks on the cartridge, correct? For the extractor, probably not. It would be more of the speed of which it was done. But for the ejector, because it was more impressed, that is certainly true. It could become more pronounced. Thank you, says Mr. Luttrell. Next question. Do you look? Mr. Rosie says, the court says, I'm sorry, what? Mr. Rosie says, you passed? I asked you. Did I pass? I didn't. The court says, yeah, I asked you and you said no and looked at Mr. Luttrell. Okay, sorry. I just lost my train of thought there. Did you look at the subclassification marks of the cartridge? So now Mr. Rose is asking the questions. He says, so the cartridge itself, it is possible for an unfired round to have subclass markings from the manufacturing tools. Actually, in fact, there was a 2016 article that specifically looked at Winchester manufactured ammunition. The photograph that was taken of the extractor rim, I can't determine from the photograph if that was in that type of subclass manufacturing mark or if it could potentially actually be from an extractor because the tool that is used in that manufacturing process to create the tapered cartridge case is almost the same process as the extractor mark would be. Mr. Rosie? No questions. Mr. Luttrell? You'd have to look at it under a comparison microscope, wouldn't you? Back to that. He says no. So it could be better documented through photographs, and I would evaluate it, or I could evaluate it using a comparison microscope. Either would be sufficient. Which would be the best? Again, it depends on how good the documentation is. If there's good documentation, then I would say they're on equal footing. If there's not, then a comparison microscope would be better if I were going to be opining as to whether or not what the source tool was. So a photograph is just as good as a comparison microscope? It can be. Thank you, says Mr. Luttrell. Next question. What is the relevance of cartridges having similar subclass characteristics? Can you read that again? I'm sorry. What is the relevance of cartridges having similar subclass characteristics? So it would depend if we're talking about subclass from cycling or from tools inside of the gun that were cycled, or ones that were manufacturing marks. So manufacturing marks subclass would just mean that the live round would have been manufactured in a close timeline with that tool, with the same tool in the same state of wear as another cartridge unfired round. If we're talking about the subclass on the firearm, again, it just indicates they're restricting or you're funneling of or pyramiding the potential firearms and reducing the pool that could have left those marks. Mr. Rosie said, the court says, Mr. Rosie, no questions. Mr. Luttrell, no, Your Honor. Are sequential serial numbers on guns made within the same lot, assuming that there isn't a change of numbers? So you can't associate a serial number with a specific lot because they do get dumped into the bins, like we talked about, and there could be multiple lines of manufacturing running at the same time. It is generally accepted that a close in serial number will indicate that the specific parts inside of those were manufactured within some close time frame, but it doesn't necessarily mean that they were consecutively made or even made on the same line. Mr. Rosie, no questions. Mr. Luttrell, no questions. Are you aware that Ms. Oberg's findings were verified by a second party and this party or identifier agreed with hers? Yes, I'm aware of that. Yes, we'll leave it at that. She probably had some choice words about both of them trying to railroad an innocent man there. The court says, Mr. Rosie, are there many different types of verification processes? Yes, there are. So verification can be done blindfolded when there's essentially a dialogue between the two individuals, and that's the least desirable. It's the one that gives rise to the most bias. Then there is a semi-blind type level where there may be a minimal communication or maybe policy only dictates that verification happens in very specific scenarios so that the verifier can already assume what the conclusions were based on how it was done. And that was partly how it took place in this case. That's a very long sentence. This whole thing was a run on sentence. And then, of course, there's fully blind, where all the markings are approved that the examiner might have put to indicate where they were looking. All the other items are kind of put in one big batch so that they're not previously grouped, so that you give the verifier no context clues, if you will, of what the initial examiner's opinion might have been. Mr. Rosie, and he has follow up. He says, does the verification process involve the verifier looking at the case file, kind of like the report of the original examiner, and saying, hey, you need to add some more information here? Or is that part of the process or not? It can be part of the process. Okay, I have nothing further. Mr. Luttrell. Well, in fact, that this was a verification that took place without the verifier knowing the conclusion that the examiner had reached at the time he's doing the verification, correct? You know that? I don't know that. I believe there was some testimony in a deposition, but there was no direct conversation with the verifier that the results were ever made known to them. But there was no discussion regarding whether they were grouped together or not, whether those marks were taken off or not, and the policy that is in place in the lab system is at the time was all identifications must be verified, eliminations based on individual characteristics must be verified, but everything else was examiner discretion. So that's also context clues that if you're being asked to verify something, it's more likely than not an identification. And so there's that contextual basis there as well, potentially. So if they're calling, if they've got a warrant out for you or whatever, I don't know what I was saying. Anyways, continuing on. But you reviewed the deposition of Melissa Oberg, correct? Yes, I did. And she testified that she had all of her, in 2022 and 2021, she had all of her examinations, whether it was inconclusive or an identification or an exclusion, she had all of her conclusions verified by a verifier. Isn't that her testimony? That is not my recollection. I believe she said that the lab was moving that direction and that that was what she supported and wanted to try to do. But I don't believe, at least as I sit here right now, I do not recall her saying that that was done on every single one of her cases. You weren't here for her testimony before this jury, where she said, in fact, all of her verification, she asked for verification on any conclusion she reaches. You weren't here for that testimony, were you? I don't know the context for that testimony, and I was not here for it. You are familiar with the name Mark Kiesler, the verifier in this case, are you not? I am familiar with his name, yes. How do you know who he is? So, I believe he was and still is potentially the supervisor at one of the ISP crime laboratories, and he was also a president, a past president, I believe, again. I'm not 100% certain on that. And he has also published some articles in the AFD journal as well. Past president of who? Of what? Of AFD. I'm sorry if I did not state that. Mr. Luttrell says, thank you. No further questions. President of AFD. Past president. Next question. These are a lot of questions, and then all the follow ups. This is taking a long time. Are you aware that the ejector from Mr. Allen's firearm had a recessed portion which caused individual characteristics in the cartridges and similar to the cartridge found on February 13th, 2013? So, generally, the extractor has a recess. It's essentially a claw. So, this, if you're looking down from the top of the gun, this is what the extractor would look like. And there's a groove on the cartridge that is right that will grab to extract and pull it out when the slide is cycled, whether through firing or manually. So generally, yes, that is the way that it works. The question that is still a question because of the lack of documentation is that surface amenable to individual characteristics, or is it like what was observed on the ejector, also having those cross continuous uniformly spaced markings that lead to the marks that are present on the cartridges or cartridge case fired in that or run through that particular firearm? Okay, that was a lot. Mr. Rosie, no questions. Mr. Luttrell. Mr. Luttrell asks, what you can take from the report is that when you saw indications of subclass, she noted them, correct? No. When she saw them for the ejector, she noted them. Yes, that is true for the ejector. So you don't know that she saw them on the extractor or the chamber face, do you? That is correct. I do not know because it was not documented. Mr. Luttrell says, no further questions. Next question from the judge. Is it normal practice for you to not issue a report when conducting examinations or consultations as you did for this case? Yes, that is. I would say probably greater than 50% of the time, it's the reports typically occur if I'm doing an actual examination of the evidence because I will list just like what all the crime labs do, list the evidence that was examined and what those results were. Dr. Rosie, no questions. Mr. Luttrell, no questions. What are the chances that the cartridge found at the scene would have the same subclass markings as the Indiana State Police Lab test results? That's a great question. We unfortunately don't have statistics for that. There are so many great guns then that get manufactured, and we can only collect so many of them. I would say that because of this idea of the consecutive manufactured parts, so generally when a firearm manufacturer is making firearms, that manufacturing process occurs. They build up some certain amount of stock. They wrap the pallet and send it to a location, and then all of those at least start out their lives in the same general area. So the chance of any Sig Sauer in this area is going to have a higher likelihood of having subclass than, let's say, guns that got shipped to Florida, at least initially when the firearm starts its life and leaves the factory. Mr. Rosie? No questions. Mr. Luttrell. He has some follow up. He says, Dr. Warren, the ejector is made by its own machine, correct? Yes. So in order for something to be manufactured, a machine has to do that. And the extractors made a different machine, correct? Not necessarily, but it could be. And the chamber face or the barrel hood is made by a whole other machine, correct? Again, not necessarily, but it could be. Mr. Luttrell says, no further questions. The court says, thank you, doctor. You may step down. The witness says, thank you, Your Honor. The court says, all right, well, ladies and gentlemen, it's a little bit late, so we're going to go ahead and take our lunch break. But you guys don't go anywhere because we're going to continue on. So they went off the record, and now we're back on the record after lunch. Everyone's bellies are full and happy. The court says, all right, we are back in the record. Is the defense ready to proceed? Ms. Auger says, yes, Your Honor. The court says, oh, yes. Mr. Rosie says, yeah, Judge, I have an exhibit, which I think is GGG, that I've redacted the portion of it that we discussed yesterday. This is the letter. Oh, okay. So I'm just going to publish it, if that's okay, with the court once the jury gets back. And that would be HHH? Okay, says Mr. Rosie. The court says, yeah, it's the printout. No, wait, GGG. That's right. GGG is the letter. HHH is the printout. You didn't admit HHH. And did we? I admitted it was a redacted version. Do you want the unredacted version for purposes of the record? Mr. Rosie says, yeah, it's already marked. So let's do that. The court says, okay. Mr. Rosie says, I think I've made some arrangements at the sidebar. Court says, you did, but I think we should probably have the unredacted, and if we don't have that, okay. So we have the unredacted version. Okay. Did you mark the page behind it also? No. Ugh. No. No. It was G. Oh, sorry. Skipped a question. Mr. Rosie asks, okay, I thought maybe you and she marked it HHH. The court says, no. It was G, 2 pages. It was the letter and the envelope. Court reporter says, yeah. Mr. Rosie says, that was. Court says, okay, so you now have copies for the jury? Yes, ma'am. This one needs to be marked because we've got to mark both of them now. Court says, that's GGG. Rosie says, submitted and denied, or the court says submitted. No. I admitted it. I admitted with the understanding that you were going to provide me a redacted copy. Oh, okay. To the jury, says the judge. Whoops. Oh my God, how did I just lose my spot there? Oh, here. Okay. I thought maybe it was the HHH. He says no. Okay, so you now have copies for the jury? Yes, ma'am. This one needs to be marked because we're gonna mark both of them now. That's that this one's the court says that's GGG, submitted and denied, or the court says no. I admitted it. I admitted it with the Mr. Rosie says, oh, okay, to the jury. Mr. Rosie says, I'm sorry, I misunderstood. The court says, yeah, no, I admitted GGG, but it was the comments that we were laughing or having. It was the comments that we were having over here about all of the other information in there that was rejected to by, I think, Ms. Diener. That's not language that I know of. Either there's some uh, errors there, like spelling errors and grammar errors, or the court just like spazzed all of a sudden and can't say normal sentences. Miss Rosie says, "You're just giving me a copy back, is what you're doing." The court reporter says, "Yep." The court says, "Okay, perfect. Okay, so with this understanding, when the jury comes back in, you'll ask to publish GGG. And then, are we ready to go?" Ms. Auger says, "Yes." The court says, "Are you doing the next witness?" Ms. Auger says, "I am, Your Honor." The court says, "Okay." Auger says, "I just have some exhibits that I was going to ask." The court says, "Okay, to be marked." McClellan says, "Judge, from the state's perspective, I believe the next witness is going to be a phone expert, and the state would ask for an exception from the separation of witnesses to have Christopher Cecil and Brian Bunner sit in on that testimony for rebuttal purposes." "Any problem with that?" says the court. Ms. Auger says, "Did you ask?" The court says, "I'm asking defense generally if there's any concerns about that." "No." Court says, "Okay, so yeah, that's be fine." Mr. McClellan says, "Okay, I'm going to bring them in, Judge, before the jury gets in." "Okay, all right. Okay, are you ready then?" Ms. Auger, "Yes, Your Honor." "Hey, Mr. Rosie," says the court, "do you have an extra copy of the redacted so that we can attach that? So if there is a conviction, the Court of Appeals has the opportunity to review the ruling that is made on the redactions. Just give that to Jody. Thank you." The bailiff says, "All rise." The court, no, then the bailiff again says, "Thank you. You may be seated." Then the court says, "Gentlemen." Well, welcome back, ladies and gentlemen. I hope lunch was okay. We are going to continue. Ms. Auger, you may call your next witness. "Thank you, Your Honor." "Judge, can I go ahead and move to publish?" says Rosie. "Oh, yes. Hold on. I apologize. Yes." Ms. Auger says, "I'll go get her while that's happening." And the court says, "Okay, ladies and gentlemen, we're going to publish now defendant's exhibit G. G, G. These triple letters are killing me. The defendant publishes it. Mr. Rosie says, "Thank you." The court says, "Thank you. I apologize, Mr. Rosie. Those are the extra copies." Mr. Rosie says, "Okay, thanks." The court says, "All right, Ms. Auger, you may call your next witness." And Ms. Auger says, "Thank you, Your Honor." We would call Stacy Eldridge. So Stacy Eldridge comes up on the stand. She's sworn in and all that stuff. Ms. Auger asks, "Stacy, can you please give us your full name?" "Stacy R. Eldridge." "And how do you spell that?" She spells it. "And I'm going to apologize since I think everything I've sent you has had two L's in Eldridge. So I'm sorry about that. Could you tell us about your education, please?" "Yes, I have a Bachelor's of Science in Computer Information Management, and I have a Master's of Science in Computer Information Management as well." "After obtaining your master's degree, what did you do for employment?" "Yes, at that time, I was employed with the FBI as a forensic examiner on the computer analysis response team, and I achieved the rank of senior forensic examiner during that time." While in the FBI, I did continue my education and training by taking additional computer and technology classes specifically related to computer forensics, mobile phone forensics, tablets, iPads, things of that nature. And then I have since continued my education and training since I left the FBI, taking over 110 computer forensic and mobile forensic classes. So she's the real deal here. I am going to show you what I have marked as Exhibit PPP P as in Paul. Can you tell me what that is, please? That's my CV. Okay, and does that include all of your education, work experience, training education? Yes, it does. And when was it last updated? It was last updated this year in August. Thank you. Move to admit triple P. One foundational question, Judge, if I may, says McLeland. Yes. McLeland says, Ms. Eldridge, under the expert witness portion from October of 2011, it looks like it's incomplete there. Did you have the remaining information, United States District Court from the Central District of California, United States of America versus, and then it just says docket 11 dash. Do you have a complete case number or case name for that? Unfortunately, I do not. Okay, I don't have any other questions, Judge. No objection to the CV being admitted. All right, I will show Triple P is admitted. May I publish? You may. May I call you Stacy? You may. Okay, I'm going to give you a copy of Triple P for you to refer to for one moment and for your first job after, sorry. May I proceed? Yes, you may. Thank you, says Ajay. Your first job after obtaining your master's was with the FBI, is that correct? I attained my master's while I was with the FBI. Okay, I'm sorry. How long did you work at the FBI? For approximately 10 years. While you were there, you worked for the Computer Analysis Response Team as a forensic examiner? Yes. Can you tell us what that is? Yes, that is the personnel within the FBI that are responsible for gathering and maintaining and preserving digital evidence. And then we're also responsible for examining that digital evidence. And digital evidence is basically anything that can store data. So today it's your laptops, your cell phones, even your smartwatches. But sometimes we took stuff off of DVRs and gaming stations and things of that nature. Then you also worked as a digital evidence instructor. Yes, I did. Okay, and what is that? That is where I moved up to headquarters and I was responsible for the training program to get new FBI digital forensic examiners up to speed. And then I also conducted those training classes as well. At the time you left the FBI, what was your job title? Digital evidence instructor. And then I still maintained my senior forensic examiner title at that time. Do you have any certifications for digital forensics? I do. What are those? I have several different ones. The two first ones I'd like to share with you come from the International Association of Computer Investigative Specialists. That's known as IACIS. I have their Certified Mobile Device Examiner certification, and I also have their Certified Forensic Computer Examiner certification. And then I also have another certification from Axiom, which is a forensic software company, and I use their software to conduct my examinations. And so they have me as an Axiom Certified Forensic Examiner, stating that I know how to use their tool appropriately. And then I also have another computer forensic examiner certification from another independent body named or known as JIAC. And then finally, I'm also a licensed private detective in the state of Nebraska. Do you also have a certification for Cellbrite? I formerly had a certification for Cellbrite, was in the FBI. I let that lapse since I no longer use it. And then I was also a former cell phone certified examiner in the FBI as well. What do you do now? I do a couple of different things. The main thing that I do is to provide the digital forensic examination and consulting. And then I also am an adjunct professor at two different universities. Have you as part of your work as a digital forensic examiner or analyst, have you ever tested before or testified before? Sorry. Yes, I have. I testified 3 times for the government when I worked for the FBI, and then I most recently testified for the defense this year in August in St. Croix. And was all that testimony concerning digital forensics? It was. Now, when you worked for the FBI, did local law enforcement agencies send you phones for extractions or examinations? Yes. They would work with a special agent in the FBI and open up an FBI case, and then he could bring me the evidence from the local agency to work on. And was that a service that the FBI provided agencies such as the Indiana State Police? Yes. When you perform, well, let me ask you this. I'm sorry. Do you have your own business now? I do. What is it called? It's called Silicon Prairie Cyber Services LLC. And at some point in the last few months, were you contacted to review some materials in this matter? I was. Who contacted you? You did. All right. And did we enter into an agreement for you to conduct those services? Yes, you signed my letter of engagement. And you bill your time? I do bill my time. And is that how you earn a living? It is how I earn my living. What is your normal hourly rate for digital forensic work? My normal hourly rate is $400 an hour. Wow, guys, that's really where it pays, is to be an expert for anything for the defense or state. It doesn't matter. They'll pay you. Just be an expert. And are you charging us in this case? In this case, it's $300 an hour. In terms of what is usual and customary in the field of digital forensics and expert testimony, do you know where your hourly rate falls? Yes, I'm right in the middle. There are some a little higher and some a little lower. How many hours did you work on this case? On this case, I've spent about 65 hours doing the actual examination and then probably about another 15 hours of prep for the testimony. What materials did you review in this matter? In this matter, I reviewed the cell phone extraction from LG's phone. Now, I think there were a couple. There were. Which ones did you review? The one I reviewed in detail was obtained in October of 2011. I'm going to stop you for a minute, certainly. Was it 2011 or 2017? I'm sorry, 2017. Okay. Yes, 2017. And was that an extraction that was completed by Brian Bunner of the Indiana State Police? Yes, it was. Did you review any other document or any other reports or data as it relates to this case? Yes, I also reviewed the Cellbrite reports that they provided from their analysis. They had a couple of other reports from a tool known as iLeap. And then I also reviewed their written reports as well. By written reports, are you referring to First Sergeant Cecil's reports? I am. Remember, both Brian Bunner and Sergeant Cecil are going to be recalled by the state. So everything that this woman is going to say, the state's going to have some bogus rebuttal for. And it's not like they did a Google search and came up with some rebuttal evidence to put on the stand, which is crazy. It's not even like expert testimony. So by written reports, you are referring to First Sergeant Cecil's report? I am. And there were some appendixes to I could talk. There were some appendixes to First Sergeant Cecil's second report. Do you recall that? Yes, I do. Did you review those? I also reviewed the appendixes. And finally, I believe you also have you may have reviewed some depositions. Yes, I reviewed those as well. And what depositions did you review? Just First Sergeant Cecil's depositions. Now, can you explain to us, generally speaking, what kind of information is stored on an iPhone? Certainly. There's a lot of different types of information. There's probably the information that you're all familiar with, at least a little bit, right? It can take pictures, so you have your photos, videos, you can have your text messages, you can send and receive phone calls, you can use many different apps to connect to the internet and social media. So there's all of that information that the user is used to, playing with and doing things with on their phone. But then there's also more to it than that. There is the iPhone operating system on that phone as well, known as the iOS, and that is what makes your phone work. So it's kind of the thing under the hood, making sure that your phone is working. And in order to get your phone to work, it's got to log and track all sorts of different information about the things that you're doing on the phone, as well as the things that are happening in the background to make your phone work. Does it have to? Does it really have to track everything we're doing? Why don't, would you like me to take that from you? So you're not holding on to it? Thank you. Now, just generally speaking, as kind of an overview, when you conduct an examination, is this just kind of clicking on all the files and reading the content like I went through my like I went through my Word directory? What? No, it is much more complex than that. Can you tell us kind of generally speaking what that involves? Yes. So part of a lot of what my examination is doing more than just like reading text messages and looking at pictures and videos and reading emails. I'm getting, so to speak, under the hood. I'm getting underneath the operating system and I'm looking at all of those things that are taking place on the phone and the stuff that the user can't touch, the stuff that the user can't control. And I use forensic software to help me do that just because it's so technical. There's things that are basically encrypted that I can't read with the naked eye, and so it's voluminous. There's so much of it. There's so many, different files. There's so many records in every file. The only way to get through it is in a reasonable fashion, um, and to be accurate is to use forensic software to help us do this. Well, what type of? In reviewing all of the extractions and the reports, what forensic software has been used by various people, Indiana State Police, yourself, to view the data from Libby German's cell phone? There has been a lot of different software used. I couldn't even name off the top of my head everything that the Indiana State Police use, but I'm going to talk about the high level things that were used the most. So, certainly, the Indiana State Police used Cellbrite to get the data off of the phone. They used they used it to review the data during the course of their examination and their analysis. They also used Axiom, they used iLeap, and there's some other software that I did not use, so I couldn't recite those for you off the top of my head. As for me, my primary tool was Axiom, and that's what I used to do the bulk of my analysis. But I also reviewed their Cellbrite reports, their digital reports that I could interact with on the computer. I looked at those as well, and then I also used two different kinds of database software. One is called DB Browser for SQLite, and then the other one is called Forensic Browser for SQLite. And I use those because it's just much easier to work with those database files in those programs rather than trying to do everything in Axiom. So, why do we have a program called Cellbrite and a program called Axiom when we're all interacting with the same data? Well, every tool can do something a little different or it can display the data a little different. And I think it's just part of the, competitive marketplace. Choose what you like. Now, in terms of my understanding in digital forensics would include an extraction and an examination. Is that correct? Yes, those are the two main parts. Okay, so tell us what an extraction is. Sure. The extraction is the process where you go about trying to get all of the phone, or excuse me, get all of that data, get all of the information files off of that phone. And so you're using a tool to do that. And then you're going to save all the information in a special format on a hard drive. And then later, you should make a copy of that extraction for any analysis or examination or viewing that you want to do. Why is it important to do it in that order? Because if you just like get on the phone and start your examination, you are changing things. And by changing things, you could also start to make things disappear because sometimes there's only so much room to hold everything. So old stuff gets deleted off the phone. And you yourself did not perform an extraction in this, correct? That is correct. I did not perform an extraction. Everything that you viewed came from the Indiana State Police. That's correct. Now, you did, however, well, let me ask you this real quick. The Indiana State Police, one of the programs they used was Cellbrite. Yes. And that is a pretty popular program that is used every state, other countries. Yes, it's used all over the world. It's hugely popular in law enforcement. And are there different types, different categories, different types of extractions that Cellbrite can perform on different phones? There are. Can you explain that? Sure. There are three different types, and they all get a little bit different data. There's the full file system, which is the one that we want as a forensic examiner to do our examination because it's giving us not only the user's information and files, it's also giving us everything from the operating system, all of the logs and databases and preferences that the user can't touch or manipulate. And then there's two other levels. The next one is advanced logical. That gives you more of just the user's files and some preferences files, but it's not going to give you the database files or the logs that tell you more of the story. And then the final one is just the logical, and that's really just sort of the bare bones minimum of files that you can get off of a phone. When you were at the FBI and you were doing extractions, is there a kind of a best practice? Best practice is to always work to try to get the full file system off of the phone first, and you try and try and try it to get it off, because sometimes honestly it's a phone, it's on, it's live, it's changing. Sometimes you just have to try two, three, or four times before you get it to go all the way through. And whatever you're doing, you make sure to document it. If you can't get it off and it fails, you note all of that stuff. If you try again, you note all of that stuff and you write it up in your report. Now, on February 15th, 2017, Brian Bunner of the Indiana State Police did a logical extraction. Is that right? Yes. Okay. And that's just kind of the over the hood stuff. Yep. That's just the basic user stuff. So, like text messages, pictures. Do you know, did Cellbrite have the ability to obtain a full file system extraction or a physical extraction of any iPhone in February of 2017? Yes, using the version of Cellbrite listed on the Cellbrite report, it did have the ability to extract that full file system from an iPhone 6S, which is Libby's cell phone running an iOS 10.2, which is what the operating system on her cell phone. The only exception would be is if the person who owned the phone had previously conducted an iTunes backup that was encrypted to their computer, and that just means that they made a copy of it. But then they also basically put a password on it so nobody else could see that it was that it was to see what it was if they had access to the computer. Now, the full file system extraction was not conducted until October 5th of 2017. Correct. And did that delay any cause of injury or of issues? Did that delay cause any issues? That delay did cause issues, yes. What issues? Because of the delay and then the phone being shut off and on several times, in February and then again in September and again in October of 2017, every time you turn off a phone and then turn it back on, you're losing information just because of that action of shutting it off. You're losing some of the temporary files. But then as the phone ages, files get older and some files will start to drop off, 28, 38 days old. So by the time it got to October, it was, over 6 months had passed. And so I lost some data that could have been very well helpful in telling the story about what was happening in this case. They lost data because it got turned on multiple times. Was there a specific piece of data that you felt would be helpful that was missing because of that? The main piece of evidence that I felt was missing is a file called the current power log, and that tells you exactly when a phone was shut off, and the only one stays, and that one only stays for basically every time you shut it on. What? the next time you shut it off. The previous stuff is wiped. So basically, one cycle of off on, you're going to lose data. And so, I didn't have any data from that log when the cell phone shut off on February 14th of 2017. And it also contains a log of other information about what's happening on the cell phone since, such as it went into airplane mode. Now, there are current power log entries on First Sergeant Cecil's timeline. Yes. So some of that data did remain on the phone. Is that right? Some of it is there. There is a lot of it from October of 2017. So some of that data did remain on the phone. Is that right? Some of it is there. There is a lot of it from October of 2017. But the last time it switched off, that is now missing? Yes. All right. Now, Stacy, can you tell us you examined the data from the phone? Yes. Is that correct? Yes. And if you could, tell us your process. Sure. So, when I first started this case, I asked, what are your two main priorities? And we'll start with that because time and budget is always an issue. And at the time, it was we want to see what was going on in the iPhone health database. So, what was going on with steps and distances? And then the other main point of concern was what was happening on the phone at 4:33 a.m. on the 14th to make it suddenly receive all these text messages. What happened then? What happened right before it? So that's where I started. And were you in terms of, let's start with the Apple Health Watch or health data? Certainly. Well, let me ask you, I'm going to backtrack. I'm sorry. Did you download the Knowledge C database? I did, yes. Okay, tell the jury if you could what the Knowledge C database is, what it does. The Knowledge C database is one of the main databases that is tracking a lot of what you were doing on your phone and what is happening on your phone. So as your screen comes on and off, it records that. It also records your battery percentage. It records the app that you were looking at and for how long. And so it can tell you that you're switching between Snapchat and then you're going into send an email. It's logging all sorts of information like that. So it's very insightful as to what you were doing on that phone and what was happening. And that information that is direct from the extraction, is that correct? Yes, I exported it straight from the extraction. Okay. And then did you also pull out part of those as kind of a separate exhibit? Yes, I did. All right. So first of all, let's start with Ms. Auger says, Your Honor, I'd move to admit defendant's exhibit TTT, which is the Knowledge C database. It's offered. McClellan says, Judge, I'm going to need to examine that. This is the Knowledge C, says Ms. Auger. Mr. McClellan says, I haven't been shown that before today, so I don't know what it contains in the zip drive. So, Judge, I'm going to need a moment to examine that. All right. Well, while they're looking at that, let's do this. Stacy, you also examined First Sergeant Christopher Cecil's timeline. I did. And that has previously been admitted to Defendant's Exhibit E. Does that look familiar to you? Yes, that looks familiar. Okay, and you have received Christopher Cecil's August 18th, 2024 report, which is State's Exhibit 227. Yes. Now, with respect to Exhibit E, excuse me, before we go on, would counsel approach, and we have a quick sidebar. The court says you've moved an exhibit. He's asked for time to review it, and we're going on to other things while he's reviewing. Ms. Auger says, okay, I can give him time. That's fine. Mr. McClellan says, I just need to quickly review this. Ms. Auger says, that's fine, and see what it is. Court says, and why didn't we get this before 5 minutes ago? Why didn't we? We? Judge Gull and Nick McClelland are a we? Why didn't we get this? See that? Why didn't we? Ms. Auger says, well, they've had it since 2017. So you're saying it's part of the extraction? Yeah. It may be, says McClelland. I didn't see the zip drive. Okay, so you didn't have the zip drive? Right. Okay, how long is it going to take you? McClelland says, just give me 40 seconds to see what it is. Okay, says the court. Sidebar over. McClellan says, okay, Judge, the state had a chance to examine defendant's TTT, and I have no objection. All right, the court says, all right, TTT is admitted without objection. Ms. Auger says, thank you. Okay, Stacy, Your Honor, is it all right if she comes down? Sure. Thank you. Okay, Judge, can we scoot the TV back at all? So Ms. Auger says, can you? Ms. Diener says, we can see it. Ms. Auger says, I don't want to touch your very expensive. Ms. McClellan says, you've been touching it the whole trial. Now you don't want to? Wow. That's an inappropriate comment. Ms. Auger says she doesn't want to touch their expensive equipment. And he's like, now you don't want to? So now I actually haven't, but I will. I'm happy to. She says, Ms. Diener says, not too much, because I want them to be able to see it. There you go. Okay. So no, I actually haven't, but I will. Ms. Diener says, not too much, because I want them to be able to see it. There you go. Okay. Mr. McClellan says, okay, thank you. Ms. Auger says, can everybody see it? Okay, you stand here. Okay. Please. Okay. This is a lot of stuff. It is a lot of stuff. Okay. Can you explain to us what this is and how you interact with data such as this? Sure. This is the knowledge seed database that I was speaking about earlier, which is recording, your power percentages, your screen going on and off, and what app you're looking at. There's tons of information stored about it, and one of the main things in there, of course, besides the action, is the date and the time as being recorded as well. But this is a huge database, and it does not end there, or it does not end here at column L. It continues to go on. And a lot of the really meaningful information to the naked human eye, in terms of words that we can understand, tends to be at the end of the database. So if you can continue to scroll, why don't I do it over here? Okay, okay. I'm just motioning this way. Yeah, so we're scrolling, right? Yes. And this is all data? Yep. Okay. So the data that stops at column AG in this database, and this is also a view that's very similar to what I would see in a database. A database is very similar to working in an Excel spreadsheet. It's just a little more fancy. It does some more complicated things, but viewing one table looks just like this in the database viewer that I use. Now, at the end, then, in column AH, there is a column titled Z metadata viewed as text. What can you explain that? Yes. So typically, when I'm in my database viewer, and as I mentioned AG, which is called Z metadata in the last column. So if you scroll all the way over to the right, then when you're looking at it, this is going to be the last thing that you see. And depending on the type of information that's in there, if it's more complicated and robust data, the database the database viewer is going to just say blob. That's what mine shows. Huh? It'll say blob? Other ones might show it a little differently, but mine says blob. And so one of the things I first do is I will go into the column and change the view and see what I can see when I'm looking at it uh, as text to see if I can see any human words that I recognize. Why do all these columns start with Z? I don't know. You'd have to ask Apple why they name things the way that they name things. But they're all Z. They do a lot of Z stuff. They like tab Z, they like tab ZZ and ZZZ, and so you've got a table that just has a lot of columns starting with Z's at the beginning of the names for whatever reason they chose. Okay, I'm going to put that down if you want to. Okay. Ms. Auger says, now, Your Honor, may I publish Defendant Exhibit P? You already published PPP. I didn't publish it earlier. Oh, Defendant's P. Okay, wait a second. Yes, you may publish. Thank you. How are you publishing it? Pardon? How are you publishing it? On the screen. On the display? Thank you. Okay. Now, Stacy, this is First Sergeant Cecil's timeline. Is that correct? Yes. And generally speaking, are there things on this timeline that you agree with? Generally, yes. Are there items on this timeline you do not agree with? There are a few items that I agree with. And are there items on the timeline that you were able to dig a little deeper and get us better answers? Yes, I was. Okay, let's start with the things that you do not agree with as it relates to his timeline. The things that I do not agree with were the date and time that some of the iMessages, FaceTime, phone calls, and some of the voicemails were delivered onto Libby's iPhone between the 13th and the 14th of February. Was so turn this on for a minute. Was there a time when Libby's cell phone did not connect to the cell tower? Yes, I noticed throughout the course of the afternoon on February 13th, there were times where it was not connected to a cell phone, just off and on, not connected to a tower. And when was the last time that Libby's cell phone connected to a cell phone tower on February 13th, 2017? The last time it connected to a cell phone tower on February 13th was at 5:45 p.m. that day. When was the next time the cell phone reconnected to a cell phone tower? It next reconnected to the cell phone tower the next day, February 14th at 4:33 a.m., which is when all the little pings and text messages start coming into Libby's phone because it was off or not receiving. It was out of service. It wasn't receiving cell phone data. It wasn't near a cell phone tower. I don't know. Probably was turned off or something along those lines. Now, in your field of digital forensics, is it customary and unusual for you also to review records from cell phone providers? Yes. Did you, in fact, review any records from Libby's cell phone provider? I did. What did you review? I reviewed information related to the pings being sent to the cell phone and also location information that was logged by AT&T. Now I'm going to show you defendant's exhibit QQQ. Yes. Can you please tell us what that is? This is a report, a log from AT&T called the Historical Precision Location Information and I'll stop you there. Okay. Your Honor, I'd move to admit defendant's exhibit QQQ. Mr. McClellan says, a few foundational questions, Judge. Is this the entire log that you looked at when examining the historical precision to location information? I looked at more records than this. McClellan says, okay, and do you have training on how to accurately read the historical precision location information? I received this training when I was in the FBI. Bam, mic drop. And when was that? Would have been sometime during my time there, probably 2009, when I started doing more of the cell phones. Mr. McClellan says, and did that at that time you couldn't have possibly considered the information with cell tower networks and network engineering for cell towers in 2017, correct? Maybe. McClellan says, have you had any training on this since 2009? I have not had any formal training. It's been conversations taking place at conferences where somebody's presenting information on their research or just, keeping up with information and trends through research and reading on the internet as well. Well, have you had any training in any kind of network engineering or network capability here in Carroll County from 2017? I have not. Do you work for AT&T? I do not. I don't have any further foundational questions, Judge. The state objects. I don't believe this is the complete log at this point, and so I'm going to object to completeness, Judge. And I can't remember, did we stipulate to this on the stipulations? We did, says Ms. Auger. Mr. McClellan says, okay, then I don't have a foundational problem, Judge, but a foundational issue. But I think there's more to the log than just this page. And the other objection is I'm not sure she's qualified to talk about what's within this log. May I follow up, says Ms. Auger. Sure, says the court. Stacey, are the form in this record, the historical precision location information, has the form of that changed at all since you received your formal training? No, it's the same basic format. Okay, and do you attend seminars related to your expertise and your work? Do they present on things like this? Yes. And you continue to attend those seminars? I do. Would there be anything about anything that happens in Carroll County that would affect this report? Not to my knowledge. Your Honor, two things. First, in terms of, she refocused that very well. In terms of completeness, I didn't want to overwhelm the jury. This is page one of a several hundred page report, but this contains the pertinent time period that we're referring to. The way the doctrine of completeness works, as I'm sure the court is aware, that if Mr. McLeland wants to admit the rest of the document, he can certainly do so. Anything further, Mr. McLeland? No, Your Honor. Shut him up. Court says, all right, I will show QQQ is admitted over objection. May I publish, Your Honor? Yes. I'm going to give you that. Okay, says the witness. The court says you may proceed. Thank you, Your Honor. Stacey, what does the AT&T historical precision location information identified as Exhibit QQQ tell us about Libby German's cell phone's connection to the cell phone tower between 5:44 on February 13th and 4:33 a.m. on February 14th in 2017? It tells us the date and time of the last connection along with the location, the approximate location of where the cell phone was connecting at, and it's giving that location by giving the longitude and the latitude. Now, what lines should we be looking at here? So for the location, they're over towards the right, just the longitude and the latitude, that's giving you a location. Okay. And then if you work to the left, you have the connection time, which here is displayed in GMT. So we actually need to subtract 5 hours from this time. I'm going to stop you for a moment. Can you tell us what GMT is? GMT stands for Greenwich Mean Time, and it's used interchangeably with UTC time, which is Universal Coordinated Time. And that time is basically going to be the time that the time that it is in London. It's kind of a global time. So wherever you are, if you say, 1 o'clock GMT, people know what you're talking about. 1 o'clock GMT, they don't have to figure out, oh, you said it in Eastern, you know. So when they're talking about the globe, this is the time that they're going to use is GMT or UTC. Are items stored on cell phones and cell phone records, are those commonly stored as either UTC or GMT? No, they're actually stored, especially on an iPhone, in a wild array of different time formats, and a lot of them are just like number, 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 and it starts from like the number of seconds from January 1st, 1970. So there's a lot of crazy times, but when we do our exams, we're putting everything in UTC time in that universal coordinated time. So that way, no matter where you are when you did your exam, what time zone, anything happened, we're all talking about the same time, 1 o'clock UTC. And on when it says connection time GMT, how does that relate to the time in Delphi, Indiana on February 13th and 14th, 2017? On February 13th and 14th, 2017, GMT was 5 hours ahead. So all of these times we need to subtract. Yep. 5 hours? Subtract 5 hours. Yes. Okay. Now on this QQQ, there's an item an item 1. Yes. What does that line associated with item 1 tell us? That is the last connection date and time of Liberty German's cell phone. Well, what is the last date and time connection? Connection time, sorry. What is the last date and connection time? God, I read things backwards. My brain sees it the right way. Just say it the wrong way. It was at 2/14/2017 at 9:33 a.m. GMT. If we subtract 5 hours, that would be 4:33 a.m. on the 14th. So that is when that's when potentially her phone turns back on or reconnects to the tower, and all of a sudden all these text messages started pouring in from the evening before. And line 2, the next line down, can you share with us what that tells us? Yes, that one has a connection on February 13th, 2017. And this says the raw data says 2244, which would be 10:44 p.m. GMT time. And now we're going to subtract the 5 hours to get to your local time. So we're going to be at 5:44 and some seconds p.m. Was there also data on Libby's cell phone that correlated with this, that her phone did not connect between 5:54 or 5:44 and uh, start over? Was there also data on Libby's phone that correlated with this, that her phone did not connect between 5:44 on the 13th and 4:33 on the 15th? Yes, there were numerous pieces of data that showed it last connected on the 13th at 5:45 p.m. We see a call in, and then after that it says, it's disconnected and it's trying to reconnect. And then it also logs when your apps, the things you're doing, are using data and how much data it's using, and there is no data logged in between those two times. And those two times being basically 5:45 p.m. on the 13th, and then no data being used until the 14th at 4:33 a.m. Which means I think someone had to manually do something to that phone at 4:33 a.m. in order for it to reconnect, right? It wouldn't just suddenly reconnect out of nowhere. So now the timeline we looked at earlier, I think I've still got it up. First, Sergeant Cecil's timeline shows, does it show iMessages coming in between 5:44 and 4:33? It does. Okay, how would that happen? So an iMessage is very similar to a text message, except this is Apple's proprietary method of sending short messages, and this was invented a long time ago because you used to have to pay per every text message you said or sent. No, so to get around that on an iPhone, you could send the iMessages, which use data instead, and the data could include using Wi-Fi, so people would use this to message over Wi-Fi. And today, it still holds true. If you do not have a cellular data connection, if you do not have Wi Fi connection, you cannot send or receive those iMessages. But in between that iMessage going from me to you, it hits the Apple server, and the Apple server will put a date and timestamp on it as to when it was sent from the sender to the receiver. So you have the information of when it was sent, but the receiver just doesn't get it, and it's held in a queue until that phone gets back into connection with the tower, and then it'll shoot them all off in rapid succession. So even though there are items in the timeline and they're timestamped between 5:45 and 4:33, is there evidence that the phone actually received those at those times? There is evidence that it did not receive those messages at those times, some of them. Again, it was intermittent throughout the day, so some iMessages were coming in on time and some weren't. Was there any iMessage that came in between 5:45 on the 13th and 4:33 on the 14th? Yes, but well, it was not delivered then. Right. Okay. Sorry. Words are important. So, even though it was time-stamped, it wasn't delivered until another time. Correct. And was that time then after that 4:33 a.m. on the 14th? I'd have to go back and look to see when the timestamps were specific to those iMessages. Okay. Now, according to the timeline, if we look at lines 450, 451, 452, 53, 54, 55, there are some calls backgrounded. Yes. Do you know when Libby German, and then if we go on down, there's a voicemail at on line 480 that is timestamped 6 o'clock, which is the line in pink right there. Yes. Did any of those, let's start with phone calls. Did any of those calls that are timestamped between 5:44 and 4:33, did you find evidence of when those actually arrived on the phone? I could not find evidence of when the missed calls were missed on the phone, but I could find evidence of when the voicemails were used or were left from the missed calls. And what did you find as it pertains to the voicemails? So there were numerous voicemails left between 5:45 p.m. on the 13th and between the morning of the 14th at 4:33 a.m., but they were not delivered to the phone during that time frame. So, like I said, things are in a queue, and then once she gets back to the tower, everything comes back. So when were the majority of them delivered? They were not delivered to the phone until, well, the voicemail recordings were not recorded on the phone until the 17th of February. And is that another log on the phone? That is another log. I can see when I can see when you receive your voicemails. Now, as part of your work, are you familiar with the concept of a cell phone ping? Yes. What is a cell phone ping? A cell phone ping is basically a technical way to say from one technical device to another, hey, are you out there? And so when you ping, you'll say, hey device, are you there? And if it receives it, it'll say, yes, I am. And then it'll send that message back. And then hopefully the sender of the ping receives that message back that yes, they're there. A very simple version of how that works. And our cell phone pings, how are those different from the cell phone tower data that we just kind of looked at from Libby's phone? The differences I see is that AT&T is repeatedly trying to ping the cell phone after 5:45 p.m. It's doing it periodically. I think didn't they call because they were minors? The grandparents could call and say, "Our, these children are missing. Libby's missing. Can you ping the phone?" And I think that's what they did. So it is doing that periodically, and it never successfully pings that cell phone again until approximately 4:33. So from that time frame, when the phone's not connected to a tower, AT&T's tower is repeatedly trying to ping that phone to try to find a location or to find narrow down her location, and it's not pinging to the phone. After 4:33 a.m., finds it, pings it. Isn't that interesting? So, are there three data points that all confirm that there's no cell phone tower connection between 5:45 on the 13th and 4:33 on the 14th? There's at least three. And what are those? The AT&T pings, when the voicemails are delivered, and then the lack of data usage being logged. Okay. Now, I'm going to move on. Let's talk Apple Health data. Okay. How does an iPhone record or log iPhone health data or health data? So only Apple truly knows the secret sauce of how it's doing all of the recording for the health data. But foundationally, what it's doing, it is measuring the movement and the vibrations of the phone to figure out, your steps. And there is hardware built into the phone that helps it figure that out. I didn't ask, so let me back up, back to 4:33 a.m. Okay. And I forgot to ask you a question. Do you have an explanation for why the phone, if it was stationary in one place, under a shoe, under a body, between 5:44 on February 13th and 4:33 on February 14th, do you have an explanation as to why it did not connect to the tower between 5:44 on the 13th and 4:33 on the 14th? I could find no evidence on the phone to suggest what happened, so I can only conclude something external to the phone changed. Or data was wiped. But she might have been able to see if somebody was manipulating the phone during those times, she probably would have been able to see that. But at this point in time, she thinks somebody did something Like I said, somebody had to manually do something to that phone in order for that change to occur at 4:33 a.m., which is not the timeline. They, according to the state's timeline, the girls had been dead by, 3 something in the afternoon the night before. So, um, okay, so what might that be? She said I could find no evidence of the phone to suggest what happened, so I can only conclude something external to the phone changed. What might that be? It could be any number of things. Can you tell us some of them? The phone could have moved. The phone signal could have been being blocked during that time by several different methods. I think those are the main ones that I think of off the top of my head. So the phone itself wasn't like powered off or powered down, so it had to have been like they blocked it or something. What about metal? I'm sorry, what? What about metal? Oh, metal. I suppose metal. Metal can also block cell phone signals. Think about like when you go into a building and you're in an elevator, that's where your calls tend to drop. But we don't know what happened. I could give no evidence of what happened on the phone. Okay, and I apologize for that. Now we go back to the Apple Health data. Okay. So did Libby, well, let me ask you this. Is there research on the accuracy of steps recorded, distance recorded, and elevation? Yes, there is. Okay, can you tell the jury about that? Yep. So this research comes from the Forensic Science Institute in the Hogue. How do you say that? Hogue in the Netherlands, if you're familiar with that. But always, or anyways, they're a big deal and they do a lot of really good forensic research. And so they decided to go out and research this Apple Health data and they documented, it's logging all of your steps and elevation changes and distance changes, even if you did nothing to set it up. But they set out to figure out just how accurate is it, and their research demonstrated that there are a lot of different things that can impact how accurate it is. They did note that steps tend to be the most accurate. Distance can be off as much as 30–40% either way. They also said the type of motion that you're doing can greatly impact as well. So, if it's more vigorous motion, you're going to get credit for a bunch of extra steps, a bunch of extra distance, where if you're hardly moving, such as like a casual walk, very slow start, stop, it's not going to log it or not log very much of it because there's just not enough difference to detect those changes. Now, first, Sergeant Cecil in the state's Exhibit 227 on page 8 outlined some Apple Health data as it relates to steps and distance. Yes. Did you agree with what he has in his report as to the steps and distance? Yes, I saw the same information. Is there a circumstance in which a phone can move, but it's not recorded in Apple Health? If the phone is moving in a vehicle, it can note the difference between driving in a vehicle versus a person walking. So it's not going to give you step credits for driving in a car, even though there was distance traveled. And does an iPhone 6, such as the one that Libby had, does that log steps or movement if it is powered off? No, it does not. Do you know whether Libby's phone was dead when it was found on the 14th? Well, when it was found, my understanding is it was powered off. Again, I'm missing that log. I didn't have any data in the log to say exactly when it was shut off. Was there any activity on Libby's cell phone after 4:35 a.m. on February 14th that would suggest that her phone was on? No, there was no data logged, nothing logged. Okay, now the timeline created by First Sergeant Cecil, is this kind of a general analysis of what was contained in a Cellbrite and Axiom report? Yeah, I would say it's general, maybe more high level. It doesn't have all the details, but it's got a lot of good data points of where it's coming from, times, times and what happened overall. Okay. And I'm going to direct your attention when you review this. Well, I think we already talked about that. Okay, so I want to talk, or I want to look at line 458 of First Sergeant Cecil's report. Yes. And it says, Knowledge C, audio output route 213 2017. We're going to adjust this for military time, 5:45:45. Audio output route start time. Do you see that? Yes, I see that row. Do you agree with that? Yes, I agree. It's written there. Okay. And if you look at First Sergeant Cecil's report on page 4, does he address audio output route? Yes. What does he tell us about that? He says in his description box that the research is incomplete, but depending on the value, it could mean any number of things based on the numbers written here. So, for example, 0, not known. 1, if there's a value of 1, it means a headset is plugged in. 2, a headset is unplugged. Or 3 is call activity. 4, user selected speaker. Or 8, unknown. And it also said that it could relate to the device's built-in microphone, receiver, speaker, or headphones, and that it may also include information about Bluetooth, MAC addresses, Bluetooth device name, and protocol. Do you agree that that research is incomplete? No. Now, in 2024, this research is incomplete. It's complete. And does that research now confirm these numbers that First Sergeant Cecil has in his report? I'm going to object, Judge. It's a leading question. Sustained. How is that a leading question? Does the research confirm Serge, Sergeant Cecil's report? I don't see how that's a leading question. Does it? He's asking, does the research? Maybe what does the research say about his report would be a better question. That's what he says. So, what does the research now tell us concerning the numbers contained in First Sergeant Chris Cecil's report? The research today tells us that there are known numeric values. For example, number 1 is headphones. Were you able to dig a little deeper and find out what happened at 5:45:24 as it relates to an audio output route start time? Yes, I was. And is that contained in the Knowledge C database? Yes. Your Honor, if I could publish what? I'm sorry? Miss OJ says, I forgot what exhibit it is. It's the Knowledge C database, TTT. The court says you published that before by display. Oh, okay. I'm sorry. Back to TTT. Did she? Oh, when did she do that? I don't remember. Okay, back to TTT. You pulled out a couple of rows of data to make it easier for us to look at. Is that right? Yes. Okay, and so if we look at audio output route, are these the lines of data that you pulled out? Yes, those are the lines of data I pulled out directly from the Knowledge C database. Okay, can you step down and explain this to us, please? Yes. All right, what does this mean? Okay, the main thing we want to know about here is just this ZPK 19600. This is just the row number assigned in the database for tracking purposes. And then all the way through here is not very meaningful to the case. Should I scroll right? Keep scrolling to the right. Well, and scroll back a little. That was a little too far, wasn't it? Yeah, that's a little too far. Sorry. We want to see some dates and times. Okay. So this date, 213 at 1:38. Should I scroll down? Yeah. There were several audio output events that day. This is the first one. But if you scroll to the bottom of this tab, you'll see the last one of the day. Okay. What does the information here tell us? The information tells us on 213 at 10:32 p.m. this record was created. Okay. And then if we move over, we have some more dates and times. If we look at Z start date in red, which is the last column there on the right, yes, in red, that tells us that, what does that tell us? That tells us when this event first started happening, which is at 5:45 p.m. Eastern on the 13th. When did it end? It ended at the column YZ end date at 2:13 at 10:32 p.m. And should I scroll to the right? Scroll over to the right. Oh, that's fine. I keep doing that. Go over one more. Oh, now I'm at the top. There we are, just a little bit. Now, when the column next to Z start date, where it says V to Z value double, what does that tell us? This is the numeric values that First Sergeant Cecil was talking about in this report. So in this case, it's logging the number 1. And according to Chris Cecil's report, what does that mean? Number 1 means the headphone. Headphone what? A headphone being inserted. Okay. Is there additional data in here that tells us or confirms that those are wired headphones? Yes. So when I was viewing it in my database viewer, it said blob. So the first thing I did was view the text information about the blob to learn more about what type of data it was. So I could convert it to the appropriate viewable format. But immediately when I looked at it as text, I could see in here entries for headphones and then the words wired headphones. Okay. Thank you. You can go ahead and have a seat. Okay. Stacy, I have an iPhone 6, and what are these? Those are headphones. Wired headphones? Wired headphones. And when it says audio output start at 5:45 on February 13th, can you demonstrate for us what that means? Yes. Let me hand you the wired headphones and the cell phone. So what happened was somebody took a headphone jack and inserted it into the hole at the bottom because this was probably your most typical headphone. I won't say most typical. It was a typical way to listen to sound on your phone, and they inserted it into the hole at the bottom at 5:45 p.m. on the 13th. What happened at 10:32 on February 13th to Libby's phone? Then someone removed that cable from the phone. So this is still the night they're still missing, have not been found yet. Somebody removed a cable from the phone, removed the headphones from the phone at 10:32 at night. According to the state, the girls are just lying there all night, even though they had tons of people searching there all night, potentially even right at that site, and no one found the girls then. So the whole timeline is wrong. The state's timeline is wrong. So she says someone removed the cable from the phone. And I should clarify that the phone can't tell if it was specifically like these headphone cables or if it was like an auxiliary input cable when you want to connect your phone to your car to listen to music. But it's definitely says some sort of cable that looked like this was plugged into the phone and then later removed on the 13th. Is that are those pretty secure connections? They are. Can you think of any explanation for an auxiliary port or headphones being plugged in and unplugged that does not involve human interaction with the phone? I cannot think of any explanation that does not involve humans. So all of the things that happened to the phone that she just explained, either headphone in or an auxiliary cord in and then again taken out, somebody had to have been doing that, and the girls were supposedly already dead by 10:30 at night. By plugging in the phone, you could stop sound from coming out of the phone as if you wanted to hide it. Objection, Judge. That's a leading question. Calls for speculation. Sustained. Withdrawn. But it's true. If somebody kept calling a phone because they might be potentially calling that person who's missing over and over again, trying to find them, a way to silence that might be to plug in your headphones to the phone so that you don't hear the ringing. So what happened immediately before an auxiliary port or headphones were plugged into that phone? There was an incoming phone call, like milliseconds apart from milliseconds right before the headphone cable was inserted. Stacy, I want to go back real quick to Apple Health data. There was also an entry at 2:32 p.m. about flights climbed. Yes. What does that mean? Those are floors, steps climbed. And in each flight, approximately 10 feet? Yes. Where were they? What? They were climbing at 2:32 p.m. There were flights climbed. So stairs, steps. Did they go into a building, a home, something? Meet up with maybe uh, Brad Weber at his house or Ron Logan's house, who are very nearby? Don't know, but that's interesting. And I don't remember if I remembered this coming out at trial, but I'll remember that now. It's kind of like the Karen Reed and John O'Keefe case. He had steps on his phone collected on his Apple Health data after she supposedly already killed him. So Ms. Auger says, thank you, nothing further. McLeland says the court. McLeland says, thank you, Judge. So now we're going to have some cross-examination of Stacy Eldridge by Nicholas McLeland. Oh, wait, I'm sorry. I forgot. This is where we're ending here. We're going to get to the second part, cross, for Stacy Eldridge next, in the next episode. We're also going to hear the rebuttal. So the rebuttal case for the state is going to start. The defense is going to rest. And what else? Oh, so the rebuttal starts with like Lieutenant Brian Bunner and who is it? Oh, First Sergeant Christopher Cecil. So they're going to potentially try to clean this up now after it comes out that there were multiple 10 feet of each flight is approximately 10 feet. How many feet did it say? Those are floors, steps climbed. It doesn't tell us how many steps climbed, though. I don't know, but we know that there were steps climbed, maybe possibly going upstairs. Maybe they were in a house or some kind of building. We know that an auxiliary cord or headphones were plugged in after the time where the girls would have already supposedly been dead, according to the state, and someone takes them out at 10:32 at night. So who's doing this? Someone's manually manipulating this phone, and it's supposedly sitting under Abby's body under a shoe and not to be found until afternoon the next day. So someone's lying here. Someone is not telling us the full truth. But we already knew that. We knew that these people were lying liars who lie. That is where I leave you today. We will continue, like I said, with Stacy Eldridge and finish up. We have 2 more episodes before we get to like closings and stuff. So this episode, um, not this, I don't know why I counted this episode, not this episode. I don't know what I meant to say. The next episode is going to be the beginning, Stacy Eldridge, the end of defense's case and then the beginning of the state's rebuttal. We will complete the state's rebuttal next week in our Tuesday and Thursday episodes, and then we'll have closings, verdict, sentencing finally. So that will be, we'll have, if you count the closing, then we have 3 episodes left, but two more testimony episodes. So that's where we are. Just wanted to give you guys an update. Also, let me know what case you guys want to look into next. I'm really thinking about the West Memphis 3. We could do Baldwin and Eccles testimony because they had a joint trial. We could see how that worked, having a joint trial. Actually, their other co-defendant was tried, Jesse Miskelly was tried by himself, and he was tried first because I think it was easier for them to get the conviction on that because he confessed. So that's what they did. And then when it comes to the Baldwin and Eccles case, I think they really lean into like the Satanism and stuff. So that I think that's going to be interesting if you guys are interested in that, where they try to tell them like, it was sacrifice or whatever. So there's that. Or Stephen Avery is another one that I'm thinking about. I kind of started him a little bit in the past, but we only read like portions of testimony from that trial. We could sit and read the whole thing if you guys are interested. Or if there are other high profile cases where we don't have cameras and want to know what actually went on in the courtroom. Let me know your thoughts for the next trial that we cover on Trial Transcripts Exposed. Thank you guys so much for watching. I will see you in the next one. Take care. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.